this meeting to order and to welcome everyone who's here in the room, as well as to all of those watching us in a streamed capacity. So that worked so well last time. I'm glad we're continuing to do that. The first order of business is a vote to adopt the July 18th, 2014 public meeting minutes. Is there a motion to do so?
So moved.
Second?
Second.
All in favor?
Aye.
Any nays? Okay, the minutes carry. Now, a few preliminary matters. I'd like to discuss the Fair Sentencing Act report. I'm pleased to announce that this report was submitted to Congress earlier this week, and it assesses the impact of the Fair Sentencing Act of 2010, which, among other things, reduced the statutory 100-to-1 drug quantity ratio of crack to powder cocaine. Our report assessing the impact of the Fair Sentencing Act found that the act reduced the disparity between crack and powder cocaine sentences, substantially reduced the federal prison population, and resulted in fewer prosecutions for crack cocaine. Despite the reduction in penalties, the rates of crack cocaine offenders cooperating with law enforcement have not changed. I'll also add that the graphics and the format of the report made it very easy and enjoyable to read, and I thank the creativity of everyone on staff for making sure that was true. And all of these wonderful, events happened while crack cocaine use continued to decline. And I just want to emphasize that. So the full report is available on the Commission's website. With respect to our national training seminar, also, I hope a big success because already approximately 1,000 individuals have registered to attend the Commission's annual national seminar on federal sentencing guidelines, which will be held in New Orleans on September 16th to the 18th. Registration is now closed. We're into overflow hotels, and I'm hoping it'll be a big success. Now, I already warned him that I'd be embarrassing him. I would like to acknowledge David DeBold's service as chair of the Practitioners Advisory Group, or as we often call it, PAG. Washington's full of these acronyms. In October of this year, David DeBold's final term as chair of the Commission's Practitioners Advisory Group will expire. And I wanted to take this opportunity on behalf of the Commission to publicly acknowledge and thank him for his exemplary years of service to the Commission. It's actually hard to imagine a hearing where you're not going to be there smiling and giving us good input. In January of 2009, the Commission adopted a formal written charter for the Practitioners Advisory Group. The Commission did so in order to ensure that a diverse cross-section of the private defense bar was well represented on the advisory group. The charter also empowered the chair and vice chair of the PAG to appoint attorneys and other professionals in criminal defense fields as non-voting members. It was important to us to have the newly constituted PAG chaired by an individual highly versed in federal criminal defense matters. That was you, Mr. DeBold. And we selected you as chair. He's a partner at the Washington, D.C. office of Gibson, Dunn & Crutcher, where he practices in the litigation department with a special emphasis on appellate matters, internal investigations, and complex civil and criminal cases. Prior to joining Gibson Dunn, he was an assistant United States attorney in Detroit, Michigan, where he served in both the criminal and appellate divisions. In 1991, he served as special counsel to the Commission and has lectured nationally on federal sentencing issues. He graduated magna cum laude from Harvard Law School and was a law clerk to the Honorable Cornelia Kennedy of the United States Court of Appeals for the Sixth Circuit. So we have a certificate of appreciation. I'm hoping you will come up and take it. And this is really well-deserved and doesn't begin to express our appreciation for everything. Thank you very much. So speaking of defenders, people who well represent the defense point of view, I would also like to introduce several of our new detailees who recently joined the staff of the Commission for 1 year detail. So on loan to the Commission for 1 year is David Porter, an assistant federal public defender from the Federal Defender's Office for the Eastern District of California, where he has worked since 1995. We're so pleased that the federal public defenders have continued their commitment to provide a detailee to the Commission. We value your input. We value the input that we routinely receive from the federal public defenders. Having a federal public defender from the field join the staff of the Commission provides meaningful assistance to us in the development of sentencing policy. And this detail is only part of the excellent input we always receive from the Federal Public Defenders Sentencing Resource Council. We get this input formally and sometimes informally, and I very much appreciate your being here. So could you stand so we could all... And with great pleasure, I also like to introduce Cynthia Lee to you. And the only reason I say that is because, you see, she escaped from us in Massachusetts a few years ago. She used to be an assistant United States attorney who would routinely appear in front of me. Then she disappeared, and I thought, where'd Cynthia go? And it turns out she went to Hawaii. Now, given our last winter, I think that was the wise move to make. But she's been prosecuting fraud there since 2012. We're very pleased that the Department of Justice has agreed to let her join the staff of the Commission for a year as well. Cynthia, could you please stand? So the next item of business is getting to a possible vote on various amendments. So we'll begin with the technical amendment, and I turn this over to Ms. Grilli, who will advise us on this matter.
Thank you, Judge Saris. This proposed amendment makes certain technical and conforming changes to the commentary in the Guidelines Manual. First, the proposed amendment reorganizes the commentary to 1B1.3 so that the application notes better reflect the order of the guideline provisions to which they relate. The proposed amendment also makes stylistic changes to the commentary to 1B1.3. To reflect the renumbering of the application notes, conforming changes are also made to commentary of other guidelines. Second, the proposed amendment makes clerical changes to correct typographical errors in Application Note 8D of 2D11 and Application Note 7 to 8C 2.8. A motion to promulgate the proposed amendment with an effective date of November 1st, 2015, and with technical and conforming amendment authority to staff is appropriate at this time.
Do I hear a motion?
So moved.
Second? All in favor?
Aye.
Any opposed? It carries. Ms. Grilli?
Yes, Your Honor. The next item of business is a possible vote on the final priorities for the 2015-2016 amendment cycle. In June 25th of 2015, the Commission published a notice of possible policy priorities in the Federal Register and received and reviewed public comment in response to that notice. A motion to adopt and publish in the Federal Register the final notice of policy priorities for the Commission's 2015-2016 amendment cycle would be in order at this time.
Do I hear a motion?
So moved.
Second?
Second.
Any discussion? All in favor?
Aye.
Any opposition? All right. Next.
Yes, Judge. The next item of business is a possible vote on adoption of a revised statement of reason form, and that form is before you. In Title 28, United States Code, Section 994W, there is a requirement that sentencing court's written statement of reasons for the sentence imposed be stated on a written statement of reasons form that is issued by the Judicial Conference and approved by the United States Sentencing Commission. At the direction of the Commission, the existing Statement of Reasons form, last revised in September 2011, has been further revised, in large part, to obtain information about the reasons underlying a sentencing court's decision to vary from the guideline range pursuant to the court's authority under 18 United States Code, Section 3553A. The revised form is before you for your consideration. A motion to adopt the revised form with technical and conforming amendment authority to staff would be in order at this time.
So moved. Second.
All in favor? Aye. Anyone opposed? Find that the motion carries, and I'd like to briefly explain why the Commission voted today to adopt a revised Statement of Reasons form and explain the next steps in the process before courts must begin using the form. In the current version of the form, when a court varies from the guideline range pursuant to one of the 3553A factors, the statutory factors, the court checks a box on the form indicating that the particular factor or factors that the court determined to be relevant, it checks off the box. So, for example, the court could check the box next to the section that says the nature and circumstances of the offense and the history and characteristics of the defendant. The current form also includes a section in which the court can explain those facts, which justified its sentence. Some judges complete this section, some do not. The revised form adopted today adds additional checkboxes to the form under the relevant 3553A factors with reasons for variances commonly supplied by courts on the current form. So in other words, our staff went through the kinds of reasons the judges have used over the years and tried to capture them. With the advent of the new form, the Commission hopes to collect more robust data about variances that will guide the Commission's development of sentencing policy in the future. The revised form will also provide a record of the court's reasons. This form does not take effect immediately. It still must be issued by the Judicial Conference. I have been advised that the Criminal Law Committee has recommended that consideration of the revised form be included on the Judicial Conference's consent calendar for a September meeting. Assuming that the conference approves issuance of the form, it would take effect at the beginning of the fiscal year or about October 1st, 2015. If so, the Commission will notify the courts about the revised form and will provide the necessary training on completion of the form. So the next item of business is a possible vote to publish in the Federal Register a proposed guideline. Ms. Grilly?
Yes, Judge. You have before you a proposed amendment, which is a result of the Commission's multi-year study of statutory and guideline definitions relating to the nature of a defendant's prior conviction. For example, crimes of violence, aggravated felony, violent felony, drug trafficking offense, and felony drug offense, and the impact of those definitions on the relevant statutory and guideline provisions. The proposed amendment is also informed by the Supreme Court's recent decision in Johnson v. United States relating to the statutory definition of violent felony in 18 United States Code Section 924E. That case held that an increased sentence under the residual clause of the definition violates due process. The proposed amendment contains several parts that the Commission is considering and includes issues for comments. Part A of the proposed amendment amends 4B 1.2 to delete the residual clause from the definition of crime of violence contained in that section. In addition, the proposed amendment amends 4B 1.2 to clarify and revise the list of enumerated offenses contained in the definition by making some revisions to that list, moving all enumerated offenses to the guideline, and providing definitions for those enumerated offenses in the commentary. Part B revises the current definitions in 4B 1.2A and B regarding what is a felony offense under state or federal law that would classify for these crimes of violence. The proposed amendment adds an additional requirement that the offense must also have been classified at the time the defendant was initially sentenced as a felony or comparable classification under the laws of the jurisdiction in which the defendant was convicted. And finally, in Part C, the proposed amendment would revise the definitions of crimes of violence and drug trafficking offense in 2L 1.2 to bring those definitions more into parallel with the definitions proposed in Parts A and B in 4B 1.2 of the Guideline Manual. A motion to publish the proposed amendment that's before you with a public comment period closing on November 12th, 2015, and technical and conforming amendment authority to staff is appropriate at this time.
Do I hear a motion? So moved. Do I hear a second? All right. Any discussion? All in favor?
Aye.
Anyone opposed? It carries. I want to take a few minutes to discuss the proposed amendment we voted to publish today, because as those of you who regularly follow the Commission's work now know, publishing an amendment for comment in August is a little different than our usual practice. With our vote today, we are seeking comment on proposed changes to existing guideline definitions relating to the nature and impact of a defendant's prior convictions for a crime of violence. The proposed changes are primarily intended to comport the sentencing guideline provision applicable to certain repeat career offenders to the Supreme Court's recent decision in Johnson versus United States. In Johnson, the Supreme Court struck down as unconstitutionally vague a portion of the statutory definition of violent felony used in a similar penalty provision in the Armed Career Criminal Act. While the Supreme Court in Johnson did not consider or address sentencing guidelines, the statutory language the court found unconstitutionally vague, often referred to as the residual clause, is identical to language contained in the career offender sentencing guideline. Consistent with Johnson, the proposal would eliminate from the guideline definition of crime of violence the residual clause, which provides that a crime of violence includes a felony offense that otherwise involves conduct that presents a serious potential risk of physical injury to another. In addition, the proposal would provide definitions for several enumerated crimes of violence. We already see litigation over the impact of Johnson on the sentencing guidelines. In light of the uncertainty resulting from the Johnson decision, we feel that it is prudent to begin considering whether, as a matter of policy, the guidelines should also eliminate the residual clause. We want to begin the process of seeking public comment so that the Commission would vote on a guideline amendment as early as possible, perhaps as soon as January 2016. However, I emphasize this proposal is only preliminary, and we look forward to public comment further informing us on this complex topic. We also intend to continue to study recidivist enhancements, including those based on prior drug convictions in the guidelines, throughout the upcoming amendment cycle. Today's vote is the start of that process. Anybody else? Okay. Is there any other business before the Commission? All right, hearing none, is there a motion to adjourn?
So moved.
Is there
Second.
all in favor? Aye. Anyone against? We're done. Thank you very much. Do we stand in recess? We stand in recess. I'd like to thank
Whatever you
staff
want
for
to
all
say.
the work that they did on all these amendments and priorities and the reports. Thank you.
Thank you.